I'm Michelle Mollaghan, a director of Isadore Goldman. The firm has one of the longest established and best known insolvency practices in the country. Over the years, we have dealt with numerous cross-border insolvency issues and estates, both within and beyond the EU. In the UK, we have some of the most experienced and resourceful cross-border restructuring insolvency professionals in the world. And the English legal system continues to provide one of the best within which to practice their art. Whilst other jurisdictions may seek to compete with our schemes of arrangement, our restructuring plans, and even with London as a leading financial hub, but we will remain at the forefront of cross-border restructuring insolvency, Brexit notwithstanding. Obviously, Brexit and indeed COVID have potentially impacted upon the efficacy of our insolvency and restructuring tools, and that is the focus of today's webinar. I'd like to introduce our speakers today. Marcia Shekerdemian QC, who is well known to most of you, is a highly regarded leading practitioner in all aspects of contentious and non-contentious insolvency, company and partnership law, as well as commercial litigation. She also sits as a deputy ICC judge. Today, she will be both chairing and presenting on behalf of Claire Stanley QC, who unfortunately is otherwise engaged. Daniel Lewis, whose insolvency practice has a particular emphasis on cases with an international element, particularly offshore asset recovery cases. He is highly experienced in bringing and defending claims against directors, including claims for misfeasance, breach of duty, asset recovery cases, and disqualification proceedings. He regularly acts on claims against directors arising from their participation in tax schemes and tax evasion. Rachael Earle's practice covers all areas of individual and corporate insolvency. In particular, she has extensive experience of complex misfeasance claims and cases involving allegations of fraud and dishonesty, often with an international element. Jamie Holmes has a busy practice focused around corporate and personal insolvency, trusts, probate, and civil fraud, with extensive experience of freezing injunctions and other forms of interim relief, as well as arbitrations across the UK and internationally. I will now hand over to our chair, Marcia Shekerdemian.
Thank you very much, Michelle. Good morning and welcome to everybody. Just a few inevitable and doubtless tedious housekeeping points. This session is running on the Zoom webinar setup, so everyone except the speakers is automatically muted, and as attendees, all your videos are all switched off. We're very keen that today we should have an exchange of views and that this session should be as interactive and dynamic as possible. So if you've got questions as the speakers are going along, we'd encourage you to put those in the course of each presentation. And if you do that, please use the Q&A button at the bottom of your screen rather than the chat button. And you can ask questions throughout the session. And I will field those questions, and obviously I will do my best to make sure that only the really difficult ones get put through to our speakers. And you can, of course, ask questions anonymously if you wish to. So let's get down to business. From the perspective of a cross-border insolvency lawyer, this Brexit has in every sense been a hard one. And there are so many questions left open and unanswered. So what are we going to look at? How do cross-border insolvency cases between the EU and the UK now work in practice? What's left of the European regulation and what can we do with it? And how far does the model law enacted into our legislation by the cross-border insolvency regulations help in filling in the gaps? Now, obviously, we hear a lot about universalism and the extraterritorial reach of the Insolvency Act, but how far does it actually work in practice? And how important is it going to be that we revert to those first principles now? What are our principal tools for obtaining recognition and enforcement? How do we serve out These are just some of the questions that we're going to be exploring today. On which note, I'll introduce our first speaker, Rachael. Rachel's going to talk about the reach of the English court post-Brexit. She's going to cover service out of the jurisdiction and the jurisdiction of the English court to open insolvency proceedings and the extraterritorial effect of certain of the Insolvency Act provisions. So over to you, Rachael.
Thanks, Marcia. So looking first at service out of the jurisdiction, pre-Brexit, a claimant didn't require permission to serve a defendant outside of the jurisdiction, where the court's power to hear the case derived from, for example, the judgments regulation or the recast insolvency regulation. But post-Brexit, so from the 31st of December 2020, those EU regulations don't apply. So where does that leave us? CPR Rule 6 has been amended, and a claimant can now serve without permission only in Scotland, Northern Ireland, or where jurisdiction is conferred on the English court by the Hague Convention, so where there's an exclusive jurisdiction clause. The Civil Procedure Rule Committee, which sounds like a fun committee to be on, has in principle approved a further amendment to allow for service out without permission where the claim falls within a choice of law agreement in favour of the English courts, not otherwise covered by the Hague Convention. But the short point is, for everything else, you're going to need permission to serve out. So that means for most of the Insolvency Act claims that we're familiar with, not based on contracts with choice of law clauses, you're going to need permission to serve out the jurisdiction where the defendant or respondent is based in the EU now. So looking at the position where you may serve out with permission of the court, a claimant can serve out if they can show, one, a good arguable case that the claim falls within one of the gateways in Practice Direction 6b, two, that there's a serious issue to be tried on the merits, and three, that England is clearly the appropriate forum for the trial. In terms of those practice direction gateways that are most likely to assist in Insolvency Act claims, Gateway 11 deals with claims about property within the jurisdiction. Gateway 12 relates to trusts. Gateway 15 relates to claims against constructive trustees. So that's going to assist where you have a director that's misappropriated company funds, taken money out of the company, and they're to be treated as a constructive trustee. Gateway 16 claims for restitutionary remedies. So again, when you're making a claim and the remedy is that the director account to the company, that's a restitutionary remedy, so Gateway 16. And finally, Gateway 20 claims under enactments allowing proceedings to be brought. So an example of this is Section 423 claims, which I'll come on to in a bit more detail later. But they're the key gateways, in my view, to bear in mind when you're looking at the typical Insolvency Act claims that we're all familiar with. As to whether things are going to get easier in the future, the UK has submitted a request to join the Lugano Convention, which would mean that permission wouldn't be required for service out on EU countries. So we'd go back to the position pre-Brexit, essentially. But it's been reported that the European Commission has indicated that it's opposed to the UK joining. So watch this space. It might get easier in the future, but at the moment it's looking unlikely. For now, the key takeaway point on service is that you will need permission to serve a defendant or respondent based in the EU, where there is no exclusive jurisdiction clause. A couple of practical points on applications for permission to serve out is that these applications can be made without notice, and they're usually determined on the papers. If permission is granted, the court will give directions about the time for the defendant to respond, the method of service, and the court may also give permission for other documents to be served out of the jurisdiction. So that's good to bear in mind, to get that in your order, because it will allow for other documents in addition to just the application notice and witness statement to be served out. In terms of the method of service, any method permitted by a civil convention or treaty is permitted, or any method permitted by the law of the country in which you're serving. So for the final point on service is that these amendments to CPR Part 6 apply to all proceedings commenced after the 31st of December 2020. You can still rely on the pre-Brexit rules to all proceedings commenced prior to that date. Looking then at the extraterritorial reach of the English court post-Brexit, so after the introduction of the exit regulations. Looking at bankruptcy and liquidation, the English court has jurisdiction to open bankruptcy proceedings or wind up a company where the debtor or the company has its commi in England and Wales, or its commi in an EU member state with an establishment in England and Wales. So commi is obviously a concept that we're familiar with, but the interesting point in respect of liquidations is that these requirements now sit alongside the old common law principles, which will continue to apply. So whether there's a sufficient connection to England and Wales. So it'll be interesting to see how those two tests work in practice. The post-Brexit legislation doesn't alter Section 221 of the Insolvency Act or restrict the English court's long-standing power to wind up companies which are incorporated abroad. It seems, in fact, that power has been extended because the English court's not bound by the commi test and can apply the lower sufficient connection test when considering jurisdiction to wind up. Looking at CVAs and administrations, not that interesting, not that much has changed. Post-Brexit, a company can enter into CVA or admin in England if it was incorporated in England, Wales or Scotland, or an EEA state. If wherever it's incorporated, it has its commi in the UK, or it has its commi in an EU member state with an establishment in the UK, or finally, it's not incorporated in an EEA state, but it has its commi in a member state or in the UK. So not as much has changed there. And the final point I'm going to talk about are the provisions of the Insolvency Act, which we know have extraterritorial effect and how they've been affected by Brexit. So sections 213, so fraudulent trading, 238 and 239, so TUVs, preferences, and 423, transactions defrauding creditors. These provisions of the Insolvency Act have all been held to have extraterritorial effect in previous cases. What does that mean in practice? It means the court can make an order under these provisions affecting persons or property outside the jurisdiction. And it also means that you can rely on Gateway 20 for permission to serve out. So where the claim is brought pursuant to an enactment, which envisages service or affecting people outside of the jurisdiction. So in those cases where the courts found those provisions to have extraterritorial effect, the courts really focused on the fact that those provisions use the word any person. So if a transaction falls foul of section 423, the court can require any person to repay a benefit received from the debtor. It's been held that that wording confers a power on the court to make orders against people or property outside of England and Wales, subject to the court being satisfied there's a close enough connection with England and Wales. But the odd one out here is section 236. So that's the power of the court to order a person to provide an account of their dealings with the company or deliver up documents. There's been conflicting High Court authority as to whether that section has extraterritorial effect. But the latest decision from the High Court in Re-Accurate Limited, which is a 2020 decision, is that it does not. So in that case, Sir Geoffrey Voss, Chancellor of the High Court, considered that he was bound by previous authority to the effect that section 2363 does not have extraterritorial effect. Now, that's at odds with the other cases, because 2363 does similarly use the words any person. The court can order any person to provide an account of their dealings with the company. So they don't really sit together logically as to why the other provisions have been held to have extraterritorial effect, but 236 hasn't. In that case, the judge in Re-Accurate, he got round this by finding that Article 6 of the recast insolvency regulation nevertheless provided for extraterritorial effect. So just as a reminder, that provision provides that where the action derives directly from insolvency proceedings, so main insolvency proceedings opened in the UK, then the courts of the UK have jurisdiction in respect of any action which is closely connected to them. So he held that pursuant to that article, 236 did have extraterritorial effect against people resident in the EU, and that gave international effect to what's otherwise a purely domestic insolvency provision. The problem is that post-Brexit, we don't have the recast insolvency regulation anymore. And as a result, it looks as though Section 236 sits an anomaly with the other Insolvency Act provisions, where the use of any person has been taken to mean that the section has extraterritorial effect. So it remains to be seen how the courts will deal with that contradiction and whether a higher court would come to a different conclusion on the construction of 236. Certainly at the moment, it seems illogical that that section doesn't have extraterritorial effect, despite using the same wording as the other provisions which have been held to have extraterritorial effect. So that's everything from me on that.
I have a question for you, Rachel, just picking up on accurate. So the effect, as I understand it from your talk, its effect is fairly limited. It only applies to production of documents from residents in EU member states and in respect of pre-Brexit liquidations.
Yes, so the decision only allows English office holders to compel the production of documents from residents in other EU member states, not other parts of the world, and only in respect of pre-Brexit liquidations.
And it's only documents.
Yeah.
And I've got my own theory, actually, thinking about it. And I was thinking about it as you were speaking. I don't pretend to have reread any of the authorities that may well have addressed this point. But I'm just thinking that maybe the distinction between any person in Section 236 and any person in those other provisions that you've identified is because of the extraordinary jurisdiction in Section 236, which is to compel the provision of information. And I can quite see that there's a distinction between compelling the production of documents and requiring someone to answer questions.
Yeah.
And on the latter, I think you'd just be the court. It's an extraordinary jurisdiction to try to exercise against somebody who's not in the jurisdiction.
Yeah, I agree, but I think that's why the focus of the courts on these words of any person is confusing, because you think it applies to all of the provisions that use that wording.
Yeah. Okay. Oh, thank you very much. I guess we have to move on, although I did have another really quite difficult question for you.
Thank you.
Oh, a question has just come in. And it's from Andy Taylor, and you're going to have to deal with this really quickly, Rachel. Even if you do get a Section 236 order, the practical problem is to get the target to comply.
Well, yes, and particularly post-Brexit now, where you'll be depending on local laws as to how you enforce your UK order.
Okay, so next up we have Daniel Lewis. Daniel's going to talk about the changes to how jurisdiction is determined for insolvencies after the 31st of December 2021. How the rules or what's left of them have changed and how they're likely to be applied in the future. He's going to look at how these questions are going to be resolved between the revised insolvency regulations as they now apply, the CBIR and the common law. Over to you, Dan.
Thanks, Marcia, and thank you, Michelle, for organising this webinar. And good morning, everyone. As you've said, Marcia, I'm going to talk about the exciting new insolvency landscape in which we find ourselves after the 1st of January. What I'm not going to do is I'm not going to pick through the bones of what remains of the legislation to see what's changed in terms of the black letter law, although, as Marcia's already said, very little actually remains. What I'm going to try and do is anticipate the direction of travel in the future of cross-border cases that involve the EU and EU entities, and look perhaps in particular at the potential practical effects for insolvency and insolvency litigation in this area. So looking at how the law will develop and where those developments might come from. But if we can just step back first of all and go back briefly to the halcyon days before the 31st of December 2020, when all was right with the world and we still had the insolvency regulation, what that meant in practice was a set of rules designed to prevent competition between insolvencies in different EU states. And very simply, that meant that you restricted the opening of main proceedings to those countries where the debtor had its COMI, and you restricted the opening of secondary proceedings to countries where the debtor had an establishment. An establishment was defined in quite a restricted way as a place of operations where the debtor carried on business in the 3 months prior to the request to open proceedings. So the insolvency regulation was actually pretty prescriptive, containing some hard and fast rules as to where an insolvency could take place. And a more positive way of looking at where we are now is that there is more flexibility as to how the courts can now approach these questions. When the sun dawned on the 1st of January this year, what were we left with? Well, as we know, we no longer had the EU insolvency regulation as we knew it. In its place, we had the catchily titled Insolvency Amendment EU Exit Regulations 2019, or as they are now referred to in winding up petitions and other court documents, the EU regulation on insolvency proceedings as it has effect in the law of the United Kingdom. That's not a title that lends itself very easily to any kind of acronym. So I'm going to just call it the revised insolvency regulations. What do the revised insolvency regulations provide for, and how have they changed in effect the law in the United Kingdom in cross-border cases? Well, the answer is almost none of the old provisions from the EU insolvency regulation actually remain. And what you're left with is really one provision in Article 1, which says where you can open insolvency proceedings. And there are 2 cases specifically provided for. The first is that the debtor's COMI is here, and the second is that the debtor has an establishment here. So stepping back, looking at Article 1, you might think nothing has changed. It's hardly revolutionary, entirely in keeping, it would appear, with the EU regulation as it was before Brexit. And it preserves as well the regulation, the distinction between main and secondary proceedings. Where there is a marked departure is in the new wording at the start of Article 1, which you might miss on a first reading, which says that the requirements for locating the debtor's COMI or establishment in the UK in order to open proceedings here is not the only basis for jurisdiction being established. Subparagraph 1 says that these rules, COMI and establishment, are in addition to any grounds for jurisdiction to open such proceedings which apply in the laws of any part of the United Kingdom. And what this short phrase potentially does is to import the entire common law rules on jurisdiction as to when the court can open proceedings. So pre-Brexit, you had hard and fast requirements, you had to show COMI, you had to show establishment within the restricted meaning of regulations. Now, you can show COMI if you want to, you can show an establishment if you want to, but you can potentially open proceedings without COMI and without an establishment in the jurisdiction if to do so is in accordance with the common law. And what this means is that the English courts can potentially assume jurisdiction where the 3-part test in lat refers is satisfied. So there must be 1, a sufficient connection with the jurisdiction, 2, there must be a reasonable possibility that a winding up order would benefit those applying for it, and 3, the court must be able to exercise jurisdiction over 1 or more persons interested in the distribution of companies' assets. And what that test does is it imposes a very much lower threshold than we've previously had to satisfy in order to open proceedings in the UK. The application of the test of sufficient connection, for example, is pretty open to interpretation. A sufficient connection doesn't require, it's well established, it doesn't require, for example, the presence of assets within the jurisdiction as a precondition for the making of, for example, a winding up order. So although the English courts have long had jurisdiction to and the power to wind up EU companies and foreign companies under the Insolvency Act, hitherto, as long as we've had the insolvency regulation, that power has been somewhat restricted. But following Brexit, we can perhaps range a bit more widely in terms of seeking insolvency proceedings in respect of foreign companies. And at this point, you can basically pick your opinion as to whether or not that's desirable. Option one, it's a heresy and undoes many decades of progress achieved by the EU in ensuring a uniformity of approach to insolvencies in cross-border cases in the EU. Option two, if you, like Derek Cummings, are obsessed with taking back control, we've done away with the prescriptive and somewhat blunt rule-based approach of the EU. And the courts now in England can do what they see as right in assuming jurisdiction in cases where it's likely to be of practical benefit. One example of this, and one area where sufficiency of connection has come up time and time again recently, has been in relation to schemes and reconstructions under Part 26 and Part 26A of the Companies Act. In many of those cases, the English courts have sanctioned schemes or reconstructions where the connection to the UK was really pretty tenuous. For example, one of the common practices was to amend finance documents to add an English jurisdiction clause temporarily with the intention that it be whipped out the moment the reconstruction or scheme's been approved. And there's been considerable sort of mission creep in terms of the courts accepting jurisdiction in increasingly marginal cases. And that was fine. That was fine as long as we had a framework of EU law in the form of the Brussels regulation or the insolvency regulation in order to require acceptance from the other EU states of those schemes or reconstructions. But now that framework has gone and the mandatory nature of that framework has gone, it's more open to doubt as to whether or not the EU will in fact accept the validity of reconstructions and schemes, for example, where the connection to the UK is very much more tenuous than coming or establishment. And what's true of schemes and arrangements and reconstructions is true more widely, I'd say, in terms of recognition of proceedings under the insolvency regulation more widely. So there's a great deal of uncertainty as to the application of how the EU countries will decide whether or not to recognise UK insolvency proceedings, where the UK courts are perhaps now more prepared than previously to countenance forum shopping, albeit perhaps forum shopping of what might be seen as the good kind rather than the bad kind. So how is this going to play out in the English courts? How's it going to be resolved? There are two potential sources of development here to fill the gap that's been left by the insolvency regulation. The first potential candidate to fill the gaps left by the insolvency regulation is the common law. But the difficulty there is the Supreme Court's already decided that the question of identifying the court of competent jurisdiction is a matter for legislation and not judge-made law. And there's good reason for that conclusion, not least because a court can't achieve reciprocity, for example, by negotiating with other countries on a treaty basis. So the judges simply can't do that. So common law doesn't provide the answer. And that leaves as the other potential candidate available to us now, the cross-border regulations. Do they provide a solution? And the answer is only partially. As a jurisdiction that has adopted the cross-border regulations, the UK is actually quite welcoming in terms of recognising and according powers to foreign office holders. And that now includes office holders within the EU. And those are what we call the inbound cases. Those are much less problematic, and there's a whole body of case law and practice that's developed around those inbound cases over the last 20 or so years. Outbound, the cross-border regulations are of much less use. They require enacting legislation in the individual states. So in this case, in each of the EU states where it's to be applied. And so far, take up within the EU has been very limited, and it's certainly not encompassed any of what might be called the key players. So while the cross-border insolvency regulations give ready access to our insolvency market, they carry with them really none of the advantages of reciprocity and automatic recognition that came with the insolvency regulation. So looking at the current situation and how this is likely to develop in the near term, it seems that the approach is going to be that recognition in EU member states is going to depend very much upon the individual laws applicable in each of the jurisdictions where one is seeking to ask for example, recognition. It seems to me as well that the EU member states are perhaps going to be less willing to exercise, to recognise proceedings where the exercise of jurisdiction by the English courts has been not in accordance with the principles that underlie the EU regulation. So where, for example, there is a tenuous connection to the English jurisdiction opening the insolvency proceedings. And that's partly also borne out by the fact that the EU now has the reconstruction regulation and is seeking to develop its own procedures and its own methods of achieving reconstructions, for example, outside of the strict insolvency process, competing therefore with the UK. So where we end up, it seems to me, is the potential for the English courts to open proceedings in a much greater variety of cases than was hitherto true, but the risk that the EU jurisdictions will be less willing to recognise those cases where the connection to the UK truly is tenuous. Marcia, I think I've probably gone over my 10 minutes, but
no, actually spot on. Dan, just one question. Quite a lot of case law, obviously, we have in this jurisdiction, quite a lot of common law, and in fact some EU law under the insolvency regulation. To what extent is any of that case law still relevant?
In terms of EU law, I think probably you can stick most of it in the bin. There are certain concepts which still apply under the revised insolvency regulations, I've already said, like Comian establishment, and we're going to have reference, I think, to EU law for some time to decide those.
Yeah, because there are EU decisions on that, not
exactly.
just English decisions.
Exactly, but I mean, I think we all know what a Comey is, and I think we all know what an establishment is. So I mean, even in those cases, are we really going to be going to the EU law to decide those questions? I think maybe tangentially, EU law is something that UK practitioners still need to know about, because I think it's reasonable to expect, as I said earlier, that in deciding whether or not to recognise proceedings opened in this jurisdiction, the EU will be looking at its own principles under the insolvency regulations it used to apply them as to whether or not it should accord recognition to the English proceedings. If, for example, you had a case where there was no Comey here, no establishment here, and really no connection here, it might be that the EU courts would, applying their own law, decide that it shouldn't be recognised.
Well, I had a recent example in a case I'm involved in where involving the French conciliation process of a Spanish aviation company, where no time was lost at all by the foreign representative in galloping over to this court to get recognition under the CBIR. And as I was flicking through the papers with gritted teeth, I remember, as you said, we're terribly generous. The court recognised the French process, but I thought they've wasted no time in coming over here to get recognition. But goodness me, how difficult is it going to be made for us when we try and get recognition over there?
Yeah, I mean, the flip side, and perhaps I keep on emphasising the positive, because I think you can be quite glass half full about this as well. The flip side is that, I mean, I've got a case where we have a liquidation of a fund in a small EU state. It's a collective investment scheme. And the liquidators have been appointed by the directors who have nicked all the money. And there is absolutely no way we can get rid of them under the law of that small EU state. However, what we can do now and what we couldn't do previously is open secondary proceedings over here, so that we can engage with all of, we can engage all of the investigative powers that the liquidators will have over here. And that would not have been possible previously without Commuron establishment.
Oh, I suppose the takeaway from that is that certainly we're going to be busy with cross-border cases now, busier than we used to be.
Yeah.
Okay, so almost finally, I'm going to hand over to Jamie. Jamie's going to talk about, picking up from Dan's talk, recognition of UK and EU insolvency proceedings in the EU and UK, respectively, and enforcement of UK and EU judgments within the UK and in the EU.
Thanks, Marcia, and good morning, everybody. Thank you also again to Michelle for organising all of this. So as Marcia says, and as I think Dan has already been joining the dots a little, I'm going to be talking about the other side of the coin, essentially, of what Rachael and Dan have already been covering. So it's one thing for the English courts to decide that our legislation has extraterritorial effect, and that we think it's proper for there to be service out, or that we have jurisdiction over various foreign companies. The potential flip side of that is our former European partners, when applying their local law rather than the EU regime that forced them to agree with us, going to agree with us now and say, yes, the English court has this flexibility, or are they going to push back against that? And as part of that's sort of the headline question, I think. And as part of that, I'm going to go through, as Marcia says, recognition of insolvency proceedings and enforcement of judgments, for example, an Insolvency Act claim, such as those that Rachael was talking about. Now, these are two each pretty big topics. Happily, Dan and Rachael have already covered some of the detail, albeit from a different angle. So I'm not going to try and in any way cover all of the detail of either topic. I'm trying to give you a few key takeaways and a bit of a framework or an overview of the position in both. So starting with recognition of insolvency proceedings. Now this is, as we've just been touching on, very much a tale of two halves, and two uneven halves at that. So firstly, and relatively briefly, what I might call inbound, so where you've got an EU member state has main insolvency proceedings and it wants those recognised in England and Wales. As Marcia and Dan have just been saying, you have the existing 2006 cross-border regulations. They still apply. We've got a relatively well-established body of familiar case law there. And I think the key takeaway is just to re-emphasise that you need to make an application to court. And then the second half of the coin, which is a bit more complicated, and is the main thing I want to talk about, is what I might call outbound. So where you've got English insolvency proceedings and you want those recognised in one or more of the EU member states. Now, the short headline point here is that you are going to need at least some form of local advice going forwards. It may be that that is just a light steer. It may be that the foreign lawyers are going to have to act for you in foreign court proceedings. It may be that you're going to need to retain them even after that to advise you as to how your local law powers are going to work once you've had the insolvency proceedings recognised. Now, if I took you through what each of the different EU member states has as its legal regime, we would be here at least all day, if not longer than that, as to a large degree they are each unique. And that's why I say you're always going to need probably at least some form of foreign law advice, at least to start with. Perhaps once we get more familiar with this, that will be increasingly less necessary. So what I want to give you is a framework. And the situation you're going to be confronted with in any given member state falls into one of roughly 4 groups. So the first and the simplest are those that have applied the same underlying UNCITRAL law that England has implemented in the 2006 cross-border regulations. So as Dan has mentioned, 4 member states have done this. That's Greece, Poland, Romania, and Slovenia. And if you are seeking recognition in one of those countries, it's essentially the same regime as England is applying inbound. So as I've said, the key takeaway is that you're going to need to make an application to court. So even while that's quite straightforward and relatively familiar, you're still going to need some foreign lawyers to help you with that. The second is where you're applying the EU member states' local law, that local law is relatively straightforward, largely conforms to either what the 2006 regs or the EU insolvency regulation provided, and allows a large degree of automatic recognition, hopefully letting you get at some assets without an application to court. But again, you're obviously going to need some local law advice to make sure you've got that right and that you are acting within the scope of what your powers are. The third is perhaps what I might describe as the default position. So you're neither in one of the previous two groups, and you're going to need to make some form of application to court before you can do anything. And that is to obtain recognition. And that again is obviously something on which you're going to need foreign law assistance. Finally, there is unfortunately an even worse group, which I understand applies only to Hungary and Denmark, which is where there is no provision under the local law in question for them to recognise English proceedings. And so you would actually need to open fresh local proceedings and start all over again. Now, as I said, I don't want to get into the detail of what all of the different countries do, but as another way of sort of cutting across this, it seems to me that there are 6 considerations you should bear in mind, because each of the member states takes a slightly different approach to these. And it may be that you have some, you get, just because one of them comes out one way in one, it doesn't mean that they'll all come out the same. These will all be relatively familiar, but I flag them because there is a risk that you might take them for granted going forwards. So the first is, what level of automatic recognition am I going to get? To what extent is the foreign court going to review everything the English court has already decided? Secondly, to what degree will a moratorium be imposed, and will I be protected from cross claims from other creditors? Thirdly, can I get at assets? And this is often the line, unfortunately, at which you need a court order before you can take that step. Fourth, can I get any interim measures to protect the position and hold the ring in the meantime whilst I apply to court? Fifth, will I be able to operate once I've actually achieved recognition, either through a court order or otherwise, under English law? Or am I going to have to operate under the foreign law of that country in question? So, for example, Italian insolvency law. And that's why I say you may need to retain foreign lawyers even after the court application to advise you as to what your powers actually are. And sixthly, what cost protection will you have, or what ability will you have to recover your costs from the estate? So tying some of that together, just to give some concrete examples, my understanding is that if you're trying to get German assets and UK's COMI, you're going to have significant automatic recognition, even to get at assets without an application to court. And the German national law largely follows what the EU insolvency regulation provided, so will be relatively familiar. So that's a relatively easy starting point. French assets are somewhere in the middle, if I can say, court describe it as that. You have some degree of automatic recognition. For example, I understand that you can get at a bank account, but not other assets. Although if you did that, the debtor and other creditors can also do that. So you don't have a moratorium or protection from cross claims until you apply to court. That said, once you have applied to court, the French courts will generally allow you to operate under English insolvency law rather than French law. So that might be described as a bit of a mixed bag. And then, for example, I understand that in a much less attractive starting point, the position under Italian law is that you're going to need an application to court before you can do anything. The Italian court might review essentially everything the English court's already decided if the other side put it in issue, and they will only then let you operate under Italian law going forwards. I mean, I suppose in some ways that is less bad, perhaps, although query if it really is, than having to start all over again in Denmark or Hungary. But you see that hopefully gives you a bit of an overview of the kind of situations you might be facing and what you need to bear in mind. And I think bringing that all back together again, it comes back to what Marcia and Dan were saying. It seems to me that it's almost a little bit like wearing a mask. You protect other people, but you don't get any protection yourself unless everybody else does it. So England having enacted the cross-border regs, it makes it very handy for other countries that want to have their insolvency proceedings recognised here. But we're going to have to go around one by one to all of these other countries and engage with their local law. And so you're going to need some foreign lawyers. So I now want to probably more briefly cover the topic of the enforcement of judgments. And here, for example, I mean what used to be known as a civil and commercial judgment under the Brussels regulation. So that might be a claim in breach of contract or tort, or more likely a claim under one of the Insolvency Act provisions. Now, Rachel's already covered off quite a lot of the detail here, because you need to bear this in mind when you're making a service out application and the like, or whether you need to make a service out application. But the sharp end of the stick is if you're then trying to enforce one of these claims having won. And the headline point to bear in mind here is that there is a patchwork of systems of rules, and you need to bear in mind two things: which set of rules apply, and then if they do apply, how do they work? Because they don't all work in exactly the same way. Now, this is in some ways going back to what the position used to be before the Brussels regulation and its forerunner in these various conventions came along. So not only before Brexit, but before the whole EU regime was built up, there was always a patchwork, and you might fall within one regime, you might not, with the default being you apply the common law. Now, before giving you a bit of an overview of that, and what I'm going to try and set out is a bit of a checklist that you can work through, although I must say it's not one that I can purport to be exhaustive. It's merely some of the things that seemed more obviously worth considering. I think it's worth emphasising 2 points that Rachel's already made. Looking back, if you managed to issue and serve your claim before 11 p.m. on New Year's Eve last year in 2020, you're unaffected by Brexit, and the old regime continues to apply. So even though your claim may not yet even have reached trial, when you get a judgment, you can enforce it and have it recognised in the old way under the Brussels regulation or the Lugano Convention. And as Rachel says, looking forward, that may be where we end up again. England has applied to join Lugano, and so it may be that this is just a sort of temporary blip for a few years before that default is restored. So in the meantime, as I say, we have this patchwork. Now, unlike with recognition of insolvency proceedings, the distinction between inbound and outbound is perhaps less important, save that, well, I'll come back to that at the end, but broadly speaking, you probably want to work through roughly the same checklist, whichever position you're in. And you need to ask yourself, do I fall within this, and how does it work if I do? So the first thing to consider is, has England managed to reach some kind of post-Brexit agreement with the country in question? Now, I'm only aware of this having occurred with Norway, and England and Norway have agreed that we're essentially going to continue to apply Lugano, even though England is actually no longer party to it. And so the same automatic recognition regime continues as before Brexit. So that's relatively easy, but pretty narrow. The second, do any of the historic bilateral treaties that were entered into long before Brexit or the EU regime apply? Now, quite a lot of EU member states signed up to these, and the 1933 Act is the touchstone here. But they include quite an attractive list of Austria, Belgium, France, Germany, Italy, and the Netherlands. Now, the editors of Dicey considered that old regime and those old agreements simply revive upon the repeal that took place as part of Brexit. But until you've got a High Court judgment that says that's the case, I would expect your opponents to challenge that in court. Now, if that works and you can say that old regime is revived, this operates a slightly different system. You have to formally register your judgment, and then it has recognition, and you can enforce it. A third point to bear in mind, and this is more one to keep in your back pocket, and it probably won't apply to most claims that you're involved in on a day-to-day basis, but is there some kind of sector-specific regime that might help? Some examples of this are carriage of goods by road, merchant shipping, or civil aviation. Now, as I say, that's not going to help in most cases, but it's worth bearing in mind and having in your back pocket in case it is in a particular case. Fourthly, again, quite a narrow one, is there an exclusive jurisdiction clause? If so, it might be that you can fall within a narrow regime that is just aimed at contracts with exclusive jurisdiction clauses under one of the Hague Conventions, the 2005 Hague Convention. Now, even if that's the case, there is a big caveat, which is that the contract in question that contains this clause must have been entered into after England joined the Hague Convention. And here again, England and Brussels disagree about what that date is. England says it's 2015, Brussels says it's 2021, which would make it not particularly useful. So again, until you've got a High Court judgment saying what the answer is, expect to be challenged on that. But if that applies, it's the same kind of system of automatic recognition that you had before Brexit. And finally, as I say, the default, if no regime applies, and I want to make clear again, I'm not suggesting that's the entire exhaustive list. They're just some obvious examples that occurred to me. If no other regime applies, you've got the default local law position. So in England, that's the common law. You'd bring a claim on the foreign judgment as a debt. You'd issue a claim form and actually sue the other side. And you'd usually seek summary judgment. And this is a well-established procedure on which there is lots and lots of old case law. And there's a whole chapter in Dicey and some very narrow defences that can be run. If you're in another member state and you're trying to enforce an English judgment, it's going to be country by country and a local law position, just like I was saying on recognition of insolvency proceedings. So bringing that together, in summary, you've got a patchwork of regimes. I suggest you come up with a tick list and work through it, and they all work slightly differently to each other, and you may need local law advice. And I think that's me.
Thanks very much, Jamie. I had a couple of thoughts along the way when you were talking about resorting to the common law. There is a valuable tool that trustees in bankruptcy now need to dust off their shelves and use again, and that's the in personam jurisdiction over the bankrupt. People of my vintage will probably remember a case called Pollard and Ashurst, and that involved the time immemorial conundrum of how to get hold of the bankrupt's holiday home in Spain. And this was a pre-EU regulation case. There was no way that the trustee was going to get recognised, even if recognition was a thing back then over in Spain. And there was no way that the Spanish court was going to give him this property. So the solution for the trustee in bankruptcy was to get an injunction against the bankrupt, who was in England, ordering the bankrupt to convey the property to the trustee in bankruptcy. So it's important to remember the existence of that jurisdiction, I think, because it's one that's going to have to be deployed, I think, probably as a matter of first resort rather than as a default. And the other thing that I can see us bringing into play more and more is essentially an anti-suit injunction, which will stop the interference by a foreign court in foreign proceedings with the orderly conduct of a domestic winding up. Obviously we have the pari passu rule here. If a foreign creditor in a different jurisdiction was trying to bring a claim and steal a march on the other creditors, the English court would have an equitable jurisdiction to stop by injunction those proceedings being brought by the foreign creditor. So I think that's another tool that we need to dust off and remember is available to us. We've only got a very few minutes left, and those few minutes fall to me to fill. And I'm just going to talk very briefly about Section 426. Now, I'm sure you'll all agree that the takeaway, one of the many takeaways from our talks, is that this is an extremely benevolent jurisdiction as far as foreign office holders and foreign liquidations are concerned. Not necessarily a bad thing, and we'd all accept that there are good economic and business reasons for that. Section 426 is another provision that is about us helping other jurisdictions. But as I'll explain, it's actually quite a useful tool for management of what are essentially domestic insolvencies of foreign companies. Section 426 applies directly in England, Wales, Northern Ireland, Scotland, and Guernsey. That is to say, all of those territories have Section 426 in their Insolvency Act. And the effect of Section 426 is to oblige the English court to assist a foreign court in a relevant territory by providing assistance where it is sought. And the relevant territories are there are many and various of those, and those of you who sleep with Celia Millman under their pillows, there's a list in page 582 of Celia Millman. But importantly, relevant territories include the Channel Islands in particular. And I'll give you an example, a real life example of how Section 426 works in practice. And it's absolutely crucial where an administration of a foreign company is under consideration. And the real life example is a case called Bet Index, or better known as Football Index, which went into administration a month or so ago. And I know we've got some people from Begbie's amongst our audience, and Adrian Hyde and other members of Begbie's were appointed as administrators. Football Index, and that's what I'll call the company, was a Jersey company. It had its COMI in Jersey, even though its business on the ground was conducted in the UK and all of its creditors were in the UK. It was screaming out for an administration. Under Jersey law, there is no such thing as an administration. How did we get into administration in the UK? In circumstances where we could not go directly into administration under Schedule B1. Well, this is the process. Application was made in Jersey by Jersey Council for a letter of request. That is to say, a request from the Jersey court to the UK court under Section 426, asking the UK court to make an administration order in respect of the Jersey company. As a matter of procedure, that application had to be supported by an English QC opinion saying that an administration order was likely to achieve the desired outcome. The letter of request having been issued by the Jersey court to the UK court, we were then able to make an in-court application for an administration order in respect of a Jersey company, and the order was made. So it's a very useful tool to bear in mind as an IP, because as often as not, you may be approached by insolvent Channel Islands, in particular, companies that trade here that have no administration option and also no CVA option. And one of the objectives of the Football Index administration was to put the company into a CVA, and a CVA simply doesn't exist in Jersey. So always remember that all is not lost if you find yourself having to deal as an IP with an insolvent foreign company that has its operations here but not its COMI here. We've had two questions come in, both from Andy Taylor. I'll read out the question. We've only got time for one question. I'm going to choose them. Actually, so it's one question, and I'll throw it open to the three of you. I'm not answering it. You can also run into what might be called conflict of laws problems, especially if the office holder is pursuing a statutory claim under the Insolvency Act, e.g. TUV, preference, 423 claim, wrongful trading, etc. To clarify, from a UK law perspective, a preference claim looks at the intentions of the company when making the payment. But under German law, it's the knowledge of the recipient creditor that matters. Start for 10.
What's the question, Marcia?
I think what Andy is saying is that the converse of the problem is that you might have a conflict of law problem where the threshold test in the defendant jurisdiction is a different one to the English one.
Yeah, I think that's obviously right, and I think perhaps that it's it becomes relevant when you're looking at the issue of whether or not the EU member state will recognise some proceedings in England in a way that it didn't used to. Perhaps whereas previously we could rely upon the fact we had the insolvency regulation to smooth over these differences. maybe in future, in terms of establishing jurisdiction, we actually have to consider foreign law much more than we have hitherto.
Thank you, and well done, Daniel.
Thank you.
We have sadly run out of time, but thank you very much again, Michelle, for organising this, and of course to Isadore Goldman. And thanks all of you for coming. If you missed any of this webinar, it's being recorded, so do get in touch with us here at Wilberforce and we can send you a link. So it's 11:02, and with that exciting start to your day, I hope you all have a lovely one. Thank you very much.
Thank you, panelists.